And I would request Senator Sigei to second this motion.
Thank you very much, Mr. Speaker. I would like to congratulate the Honorable Senator Veronica Maina for this very important amendment to the Law of Succession Act. Mr. Speaker, as I second, I would like to indicate that there are 7 proposed amendments to the Law of Succession Act, and as has been ably put forward by the mover of the amendments, Mr. Speaker, of a very critical concern and appreciation is the fact that these proposed amendments will be making the Act to comply with the various pronouncements which have been made by the various courts in the process of litigation by among many Kenyans who have had challenges with the issue with regards to succession, with issue with regards to matrimonial property, with the issue with the intestacy, because this is a country where a good number of Kenyans do not leave behind wills for purposes of the estate before they pass on. And Mr. Speaker, to be very particular, the amendment seeks to align the Law of Succession Act with the Children's Act by defining what the law now with regards to who a child is. This particular introduction of a definition of a child in the Succession Act is to ensure that adopted children can fit into the estate of a deceased person, whether father or mother, and for purposes of benefiting from that particular estate. Similarly, intermeddling of the estate in this particular proposal has been broadly defined to mean taking possession of, disposing of, charging, receiving, distributing, leasing, or using property of a deceased without authority under this Act or any other applicable law. Mr. Speaker, this particular expansion of definition is seeking to support and ensure that the very many cases which we experience where upon the demise of an individual, the estate is abused by either the surviving spouse or any other person who has got an interest, particularly in situations where that particular estate could be unknown or has not been disclosed to the family, and in ensuring that we broaden this definition of what intermeddling means, we are protecting the estate so that in the event that that was not disclosed among the properties of the deceased, the family can ensure that ultimately it will be protected. It has also expanded the definition of intermeddling to mean ejecting a surviving spouse or child from the matrimonial home or any other unlawful dealing with the deceased person's estate. Mr. Speaker, this is a very important amendment because without protection of the estate of a deceased person, the beneficiaries, the children, the surviving spouse, parents, or any other dependent on that particular estate will be left with nothing to survive or to inherit, especially where the law does not define beyond the abuse or any unlawful dealing with that estate. And the proposal by Senator Veronica to expand that is highly welcome in order to make sure that we protect these particular estates. Mr. Speaker, the proposal to amend by deletion of in the Principal Act Section 32 is one that is very critical. Section 32, Mr. Speaker, in the Principal Act provides for exclusion of certain counties, the county like Kajiado, Wajir, Marsabit, Tana River, in the Principal Act has been excluded, particularly with regards to some certain immovable property and agricultural land. The Act seeks to ensure that Section 32 and 33 does not exclude those counties in the aspects of reference to matrimonial property and also in terms of succession on agricultural land as well as movable property of a deceased person. This is in effect ensuring that anyone who is living within the territory of Kenya applies this particular law for purposes of uniformity and also in terms of ensuring that we do not abuse the existence and the application of the local regulations, the local laws, or even traditional beliefs as to who is entitled to participate in sharing or benefiting from a property of the deceased. The repealing of Section 32 and 33, therefore, of the Law of Succession Act has ensured that there is uniformity in the application of law across the country. Mr. Speaker, further, amendment of the Principal Act is as elaborately put by to ensure that if a deceased person has left intestate, the spouse who is surviving with or without children are equally protected, so that they don't lose on the entitlement merely because the law does not specifically and clearly provides for who in order of consanguinity is to benefit before the other. Similarly, the amendment to Section 36 of the Principal Act is to support and ensure that the surviving spouse, as well as children, and any other person who is to benefit from that estate is not denied of that entitlement merely because the law does not list as to who is to benefit first before the other. Mr. Speaker, under the proposed amendment to Section 39 of the Principal Act, the current law has listed the father before the mother. The proposed amendment herein seeks to ensure that both a father or mother of a deceased are equal in terms of their benefit to the estate, and therefore it proposes to say that once there is a deceased and they do not have a surviving spouse, it's the mother or the father in equal share who are supposed to benefit, and in the absence of either, then the rest of the list of the beneficiaries will apply. Mr. Speaker, I appreciate the proposed amendments by Senator Veronica, and as it has been stated, we have, as Jailer Committee, received various proposals and also concerns by stakeholders within their various areas of interest, and Jailer Committee report has already been concluded. It is awaiting adoption, and we will table it at an appropriate time, so that should there be any additional amendments that we will seek to amend or introduce, it will still be done within the time that the laws and the standing orders of this House allows. As I second, Mr. Speaker, I once again want to appreciate and thank Senator Veronica for ensuring that we amend the law in order to align it with the developments within the law of succession sector, as well as the several pronouncements and decisions that various courts have made in the course of the litigation processes that have been in this country. Mr. Speaker, I support and thank you.
Honourable Senators, I now proceed to propose the question that the Law of Succession Amendment Bill, Senate Bills number 20 of 2023, be now read a second time. The floor is open. Senator Manzo.
Thank you, Mr. Speaker, for giving me an opportunity to contribute on this very important law and amendment. Mr. Speaker, the Law of Succession is the most controversial law in many parts of Africa. The law of succession keeps on being dependent on circumstances of each case. And that's why the judgments which has come out, and sometimes they are tailored to suit a certain issue presented in courts. And in a lot of times, Mr. Speaker, the courts is encouraged to get all the interested dependents, and then they are able to agree on a settlement. I want to look at the scenario which has been presented here. First, the definition of a child. That is correct. But then sometimes people who are above 18 years, who are no longer children, become dependent or are entitled to property of a deceased person. And then, Mr. Speaker, you find that in the event of a death of a child or a son, then it used to be father and now it's going to be father and mother. So suppose that son, then he has a family. Then which way? And it becomes very complicated, and many of the matters which have been in court have been very strenuous. They take many years. All family or people who are entitled have to personally appear in court and state their position. And it's one of the matters which are extremely complicated. And again, Mr. Speaker, some people die and there's nothing to inherit. They have no property in their name at all. Sometimes, Mr. Speaker, you find it is a matrimonial property and each spouse has a contribution to that property. So then, when it is a man who is deceased and is